The first issue is whether Razak's threat to harm Rizal's daughter if Rizal did not agree to sell the two Komatsu excavators to Razak for an undervalue instead of the market value price of Rm 500,000 apiece constitutes as duress. And secondly, whether Rizal can recover the excavators from Ghazali, a third party who later purchased the excavators from Razak at a price far below market value. Rule A, the contract must arise from the free and voluntary will of the parties. If consent is coerced, the law regards the agreement as voidable at the instance of the victim. In common law, duress refers to the pressure that coerces a party's will and influences genuine consent. Lord Scarman set out the modern test for duress in Pao On and Lao Yu Long, which asks 3 questions. 1. Was pressure exerted on the claimant? 2. Was that pressure illegitimate in law, which means threats of unlawful action or bad faith threats to breach a contract? And 3. Whether the pressure caused the claimant to enter into the contract by leaving them with no practical choice but to submit. The test does not require the pressure to be the sole reason for entering the contract, only that it was a significant material cause. The doctrine of duress encompasses 3 forms: duress to goods, economic duress, and duress to the person. Duress to the person occurs when one party enters into a contract as a result of threats of physical harm to themselves or someone close to them. An example of duress to the person can be found in the case Barton and Armstrong, where Armstrong threatened to kill Barton and his wife if he did not agree to repay a loan and buy Armstrong's shares. The court held that such threats rendered the contract voidable, even though Barton also had commercial reasons for signing. The threat does not need to be the sole reason for a party's consent. Being a contributing factor is sufficient to render the contract voidable. Duress can be understood through 2 main theories. The overborne will theory sees the victim's consent as invalid because their will was dominated by fear, where the agreement was not a product of genuine choice. On the other hand, the modern illegitimate pressure theory shifts the focus to the conduct of the party applying the pressure. It asks whether the pressure itself was wrongful or unfair, even if the victim's will wasn't completely influenced. As seen in DSND Subsea and Petroleum Geoservices, the court held that the illegitimacy of pressure depends on factors such as whether the conduct was unlawful and carried out in bad faith. In short, the first theory explains why the victim's consent was not truly free. The second approach centers on the conduct of the party applying the duress and seeking to uphold the contract. In this scenario, Razak's video threatening to harm Rizal's daughter if Rizal did not comply with his demand to sell the excavators at an extremely undervalued price clearly constitutes duress, specifically duress to the person. Beatson stated that it is sufficient that the violence or threatened violence must be unlawful, and although it will generally be directed at the coerced party, it is enough if it is directed at his spouse, his child, and possibly at a near relative. As Lord Scarman stated in Universe Tank Ships of Monrovia and International Transport Workers Federation, the essence of the duress is the exertion of illegitimate pressure which compels the victim to enter into a contract which he would not otherwise have made. Applying Lord Scarman's test, pressure was exerted. It was illegitimate, and it was the decisive cause of Rizal agreeing to sell the excavators to Razak at a price far below market value. Rizal would not have agreed to Razak's demands if not for fear of his daughter's safety. Following Barton and Armstrong, threats of violence render a contract voidable, not void, meaning Razak acquired only voidable title to the excavators. As established in Carr and Universal Finance and Caldwell, voidable title can be defeated if the original owner rescinds the contract before the goods are transferred to a third party. However, since Rizal had not yet rescinded the contract at the time Razak sold the excavators to Ghazali, Razak still held voidable title at the moment of the sub-sale. The crux of the matter is whether or not Ghazali had acquired the title in good faith under the exception of Section 23 of the Sales and Goods Act 1979.
Section 23 of the Sales and Goods Act of 1979 provides that a buyer may obtain good title from a seller with voidable title provided the contract has not been rescinded and the buyer purchases in good faith and without notice of the seller's defective title at the time of the purchase. As Barker observes, the defense of bona fide purchase is grounded in the need for security of receipt and transactional stability. It ensures that a person who acquires property in good faith for value without notice of another's defect in title should not be deprived of that property by the reversal of prior defective transactions. Although Ghazali did not know about the duress, he knew that he was acquiring them at well below market value. He bought 2 excavators worth £1 million for only £100,000, a price so exceptionally low that any reasonable buyer would recognize it as suspicious. English courts have consistently held that purchasing goods at a gross undervalue constitutes notice of irregularity and defeats good faith. Thus, since Ghazali was aware of the undervalue, he cannot be regarded as a bona fide purchaser. Under Section 21 of the Sale of Good Act of 1979, a buyer cannot obtain a title better than a seller had. This reflects the general memo that quod non habet principle. A person who is not the owner cannot pass good title unless an exception applies. As Razak did not obtain good title, he therefore could not pass the good title to Ghazali, and ownership remained with Rizal. Consequently, Rizal is entitled to recover the excavators from Ghazali under English law. In conclusion, under English law, Razak's threat to harm Rizal's daughter clearly amounts to duress to the person. The threat was illegitimate and directly caused Rizal to sell the excavators at a grossly undervalued price, therefore destroying the element of free consent that is required for a valid contract. Although the contract between them is voidable at Rizal's option, Razak sold the excavators to Ghazali before Rizal could rescind the contract. However, under Section 23 of the Sale of Good Act 1979, a third party can only acquire good title if they purchase the goods in good faith and without notice of the defect in the seller's title. Ghazali paid a price so low that no reasonable buyer could regard the transaction as genuine. This gross undervalue indicates lack of good faith, meaning that he cannot rely on the protection of Section 23. Therefore, Rizal is entitled to recover them from Ghazali.
In the Malaysian context, under Section 10, Sub 1 of the Contracts Act 1950, an agreement is only binding if it's made with free consent. According to Section 14, Sub A of the Contracts Act 1950, consent is not free when it's caused by coercion, which Section 15 defines as committing or threatening to commit any act of forbiddance by the Penal Code, or any unlawful detaining or threatening to detain any property which with the intention of forcing someone to enter into an agreement. This highlights that coercion undermines the very foundation of contractual consent. A person who agrees because of a threat is not exercising real choice. Therefore, the law treats such consent as defective, reflecting the principle that freedom and coercion are fundamentally opposed. As Bigwood observed, freedom entails the absence of coercion, and coercion involves the absence of freedom. Where consent is obtained through coercion, Section 19 Sub 1 allows the agreement to be voidable at the party whose consent was not free. As with the common law, the coercion must cause the innocent party to enter into an agreement. There must be a causal link between the coercion and the entry into the contract. Upon rescission, the other party is discharged from further obligation under the contract, and the rescinding party must restore any advantage it received under the contract to the party exerting the coercion based on Section 65 and Section 66. Both parties must restore any advantage it received under the contract or provide compensation to the other party. In the case of Sapur Rasat and Harnardas 1932, the court held that a voidable contract is later rescinded by the innocent party. If that happened, Section 66 requires both parties to restore and compensate any benefits received during the contract. Finally, Section 503 of the Penal Code provides for the offence of criminal intimidation. Criminal intimidation occurs when a person threatens another with an injury to his person with the intent to cause alarm to the person or to cause that person to do any act which he is not legally bound. In the case of Utiram Sebastian and Stevenson 2009, the parties were co-directors in a company and were negotiating over shares and properties. During negotiation, a dispute arose and Stevenson's lawyer threatens to lodge a police report over alleged financial misconduct and even arranged for police officers to wait outside to intimidate Utiram. They also claimed that Stevenson had influence to ensure Utiram's arrest if he refused to sign the contract. Fearing arrest, Uthiram signs the settlement but later sought to rescind it for coercion. The courts held that the agreement was voided due to coercion. Referring to Section 15, the courts found that the lawyer's threat amounted to criminal intimidation under Section 503 of the Penal Code. The involvement of police officers created fear and pressure, showing Uthiram did not act freely. The agreement was also clearly one-sided and unfair, reinforcing that no reasonable person acting of their own free will would have accepted such terms. In this case, Razak's conduct clearly falls within the definition of coercion under Section 15 of the Contracts Act 1950 when he sent a video to Rizal threatening to harm Rizal's daughter if he refused to sell the two Komatsu excavator below market value per piece. This will amount to criminal intimidation, which is a clear violation of Section 503 of the Penal Code. Rizal's consent to sell the two Komatsu excavator was not done out of willingness, but was done out of fear and intimidation. He only agrees to sell the Komatsu excavator well below the market value because of Razak's threat to harm his daughter. This is a clear violation of Section 14 sub A, as the Act stated that consent is not free when it's caused by coercion. Therefore, the agreement made between Rizal and Razak does not constitute a valid contract and is voidable at Rizal's option under Section 19 sub 1.
However, although the contract between Rizal and Razak is voidable due to coercion, the Komatsu excavator has been sold to a third party, Ghazali. This raises a separate issue of whether Rizal could still recover the excavator from Ghazali or whether a valid title has passed. Under Section 27 of the Sales and Goods Act 1957, a person cannot transfer a better title than him himself possesses. Since Razak obtained the excavators under a voidable contract induced by coercion, he did possess the title of the Komatsu excavator, but it was voidable at Rizal's options. As Rizal had not rescinded the contract under Section 19 of the Contract Act 1950 at the time Razak sold the machines to Ghazali, Section 27 of the Sales and Goods Act stated that Ghazali may obtain good title if he purchased the Komatsu excavator in good faith and without notice of the defect in Razak's title. Although Ghazali was unaware of the coercion conducted by Razak, the fact that he paid only 100,000 ringgit for both Komatsu excavator that has a market value of 1 million ringgit suggested that the price was too good to be true and a reasonable buyer would have ought to inquire further about the below market price goods. Based on this, Ghazali would most likely not qualify as a bona fide purchaser for the value without notice. And thus, Rizal may recover the excavators or their value from him. In conclusion, Razak's threat to harm Rizal's daughter amounts to coercion under Section 14 and 15 of the Contract Act 1950, making the agreement voidable at Rizal's option under Section 19. Therefore, Rizal is legally entitled to rescind the contract and recover the excavators or their value. Since the machines were transferred to Ghazali, Section 27 of the Sales of Goods Act 1957 applies. Although Ghazali did not know about the coercion, the extremely low price he paid means he is not a bona fide purchaser without notice. This allows Rizal to recover the excavators from Ghazali.
The second issue is whether or not Rizal is liable to XYZ Bank under the guarantee he signed for Karim's loan, considering the potential undue influence exerted by Karim, and whether the bank had constructive notice of it. Undue influence is an equitable doctrine that applies in situations not covered by common law duress. It protects parties whose consent has been obtained through the improper influence of another. This doctrine renders a contract voidable at the innocent party's option. He or she may choose to affirm the contract, rescind the contract, or set up undue influence as a defense. If they choose to affirm the contract, they will lose their right to rescind the contract. As Winder explains, for there to be undue influence, there must be bullying or unconscionable persuasion leading to a position of influence such that the person using it could dominate the power of decision of the other person, rendering that person incapable of resisting his will so that the consent given by the other person was not a real expression of intention. The doctrine of undue influence is grounded on three principal foundations: the state of mind of the victim, the conduct of the defendant, and public policy considerations. First, undue influence focuses on the impaired volition of the victim, whose decision-making abilities have been compromised by dependence of trust placed in the defendant. as seen in the case of Burks and Chin Yuk-yin, 1995. Secondly, the doctrine examines the defendant's conduct, whether it involved any abuse or exploitation of confidence and trust that prompted the claimant to enter into the contract. From a public policy perspective, relief is granted not for the defendant's wrongdoing, but to ensure that trust-based relationships are not misused to secure unfair advantages at the expense of the weaker party. Undue influence may be divided into two main categories: actual undue influence and presumed undue influence. Actual undue influence arises in cases which one party had induced the other to enter into the transaction by actual pressure which equity regarded as improper, but which does not amount to duress because no elements of violence to the person was involved. It typically occurs in situations where there is no special or pre-existing relationships between the parties, such as between husband and wife, nor is there a history of influence by the defendant over the claimant. An example of actual undue influence can be seen in Williams and Bailey, 1866, where a father mortgaged his property to repay his son's forged check after the bank implied that his son would be prosecuted. The House of Lords held that the agreement was voidable for actual undue influence, as the bank's implied threat overbore the father's free will, who acted out of natural affection and concern for his son. Presumed undue influence, on the other hand, is further divided into Class 2A and Class 2B. Class 2A covers cases where a special relationship exists between the parties, such as between client and solicitor, bank and customer, and etc., which automatically gives rise to a presumption of influence. However, the claimant must still show that the influence was undue, meaning that the resulting transaction calls for an explanation or appears manifestly disadvantageous to one party. This principle was illustrated in Alcott and Skinner, 1887, which involved a special relationship between a religious leader and her disciple, who transferred large sums to her religious superior under vows of obedience and poverty. After leaving, she sought to recover her property. The Court of Appeal held that the relationship between Alcott and the lady superior raised a presumption of influence, as the plaintiff's devotion and obedience placed her under the defendant's spiritual authority. Class 2B, on the other hand, applies where there is no special relationship in law, but the facts show a history of one party, the claimant, having placed trust and confidence in the other, the defendant, especially in financial or business matters. The existence of such trust and confidence gives rise to a presumption of undue influence in respect of the transaction in question. As with Class 2A cases, the claimant must still go on to show that the influence was undue. Once a presumption of undue influence arises, the burden will shift to the dominant party to give a convincing explanation that the transaction was entered into freely and was not induced by undue influence. If not rebutted, the transaction will be voidable. In cases involving third parties such as banks, the doctrine of constructive notice becomes relevant, where a bank seeks to enforce a transaction or guarantee that may have been procured through undue influence. Equity may fix the bank with constructive notice if it knew or ought to have known that the transaction was not entered into by one's own free will. The bank must then take reasonable steps to ensure that the guarantee has entered the transaction with full, independent, and informed consent. The case of Barclays Bank Private Limited Company and O'Brien, 1994, and Royal Bank of Scotland and Ettridge, 2001, established that a bank will be put on constructive notice where the nature of the transaction calls for an explanation. For instance, where a guarantor receives no direct benefit, or where there is a relationship of trust between the debtor and guarantor. In such circumstances, the bank is expected to warn the surety privately of the risk and liabilities involved, as well as advise them to obtain independent legal advice.
In this scenario, a special relationship exists between Rizal and Karim as client and solicitor, giving rise to a presumption of undue influence. Rizal's long-standing reliance on Karim for legal and business advice further demonstrates a relationship of trust and confidence that falls within Class 2B, presumed undue influence. Karim exploited this relationship by persistently pressuring Rizal to act as his guarantor despite Rizal's clear hesitation, repeatedly calling and texting Rizal over the course of 3 weeks. In addition to that, Karim implied that Rizal was morally obliged to return a favor because he had done so much for Rizal, amounting to emotional pressure. To rebut the presumption, it must be shown that Rizal had acted freely and without any pressure. The transaction, acting as guarantor for Karim's business, was manifestly disadvantageous to Rizal and was for Karim's sole benefit. This type of arrangement clearly calls for explanation within the meaning of O'Brien, as it is not reasonable nor fair. Furthermore, Karim did not disclose the full and honest truth about the guarantee. Rizal relied on Karim's assurance that there would be no risk involved and that he would not default on the repayments, suggesting that Rizal's consent was not fully informed or independent. Given these circumstances, it is impossible for Karim to demonstrate that the guarantee was not induced by undue influence. Under O'Brien, a bank is put on inquiry whenever a transaction or loan arrangement appears to be for the sole benefit of one party, especially where there is a non-commercial or special relationship between both parties. In such circumstances, the bank is expected to warn the guarantor privately of the liability and risk as well as advise them to obtain independent legal advice. When Rizal and Karim attended the bank together, the manager's failure to make further inquiries and advise Rizal to seek independent advice after Karim answered on Rizal's behalf shows that the bank took no reasonable steps to verify that Rizal's consent was free and informed. The bank is thus fixed with constructive notice of Karim's undue influence. In conclusion, Rizal is likely not liable to XYZ Bank under the guarantee. Under the principles in O'Brien, Karim's influence is presumed to have been undue due to the relationship of trust and reliance as Rizal's solicitor. Furthermore, the bank's failure to ensure Rizal's independent consent means they cannot enforce the guarantee against him as they had constructive notice of Karim's undue influence. As such, the transaction is therefore voidable at Rizal's option.
In the context of Malaysian law, under Section 16 Sub 1 of the Contracts Act 1950, a contract is said to be induced by undue influence where the relations between the parties places one in a position to dominate the will of the other, and that position is used to obtain an unfair advantage. Unlike English law, Section 16 does not distinguish between actual and presumed undue influence. However, Section 16 Sub 2 creates a statutory presumption in situations involving real or apparent authority, fiduciary relationships, or where the victim's mental capacity is affected by age, illness, or distress. This operates similarly to Class 2A presumed influence in English law, where Section 16 Sub 2 does not apply. Akin to English Class 1 or Class 2B situations, analogous to the English law, Section 16 Sub 3 places the burden of proof on the dominant party to show that the contract was not induced by undue influence once the victim demonstrates that the other party was in a position to dominate his will and that the resulting transaction appears unfair or unconscionable. Principles are illustrated in the case of Rosli B. Darus and Mansour and Harun bin Haji Sa'ad, 2001. The claimant, who had been dependent on his uncle, the number one defendant, since childhood, conveyed inherited land to the first defendant and another uncle, the second defendant. The court held that domination of the will may be proved directly or presumed under Section 16 Sub 2, which covers all relationships involving real or apparent authority, not just the fiduciaries. On the facts, the first defendant's position of authority over the claimant justified the presumption of undue influence, and the first defendant failed to rebut it. Similarly, in Tara Rajaratnam and Datuk Jaginder Singh and others, 1983, solicitors who had advised the claimant to transfer her land to them under the guise of a security arrangement were found to be in a position to dominate her will under Section 16 Sub 2A because of their fiduciary relationship. As the transaction was unfair, a presumption of undue influence arose under Section 16 Sub 3, shifting the burden to the solicitors who were unable to rebut it. When a contract is induced by undue influence, it is voidable at the option of the innocent party under Section 20 of the Contracts Act 1950, allowing the victim to rescind the agreement. Upon rescission, Both parties must restore or compensate the other party for any benefit received under Section 65 and 66. Similar to the English position, when a third party such as a bank seeks to enforce a transaction or guarantee obtained under undue influence, they may be fixed with constructive notice if they knew or ought to have known that the guarantor's consent was not independent. Pursuant to the principles established in Barclays Bank Private Limited Company and O'Brien 1994 and Royal Bank of Scotland and Ettridge 2001 and subsequently followed in Malaysia in the Public Finance Berhad and Libby Rubber Factory 1994 case. In this case, as Rizal's solicitor and advisor, a fiduciary relationship clearly exists between him and Karim, giving rise to a presumption of undue influence under Section 16 sub 2A of the Contracts Act 1950. Rizal's long-standing reliance and trust in Karim in legal and business matters further shows that Karim was already in a position to dominate Rizal's will. As Winder observed, if the relation of the parties has been such that the one naturally relied upon the other for advice, and the transaction is one which gives an evident advantage to the person giving the advice, the court will presume undue influence unless the contrary is proved. Karim exploited this relationship of trust by pressuring Rizal over 3 weeks through calls and messages to act as his guarantor. In Karim's statement, "I've done so much for you. Can you guarantee me there's no risk I don't expect to default?" already indicates that he was exerting emotional pressure intended to influence Rizal's decision. The transaction was entirely disadvantageous to Rizal, offering him no benefit while solely protecting Karim's financial interests. This transaction is clearly unconscionable within the meaning of Section 16 sub 3 of the Contracts Act 1950. Thus, the burden of proof shifts to Karim to prove that Rizal entered into the guarantee freely and that the contract was not induced by undue influence. To rebut the presumption, it must be shown that Rizal had acted freely and without any pressure. In the case of Inch Noria and Sheikh Ali bin Omar 1929, the dominant party must show that the weaker party was acting independently, without any influence to rebut the presumption. According to the facts, Rizal received no independent legal advice, which is the primary safeguard required to show independent consent. Instead, Karim actively discouraged independent decision-making by repeatedly pressuring Rizal over 3 weeks and answering on Rizal's behalf when the bank manager asked why he was providing the guarantee. Furthermore, the transaction was entirely one-sided and conferred no benefit to Rizal, meaning that the transaction was not reasonable or fair. Karim further failed to disclose the full and honest truth, downplaying the risk by telling Rizal that there was no risk and that he did not expect to default. These factors collectively make it impossible for Karim to prove that the guarantee was not induced by undue influence. When a bank is aware that the guarantor is entering into a transaction that appears unusual or one-sided, or where the principal debtor answers questions on behalf of the guarantor, the bank is placed on inquiry. As John Mee observes, a lender who ignores clear signs of undue influence or misrepresentation cannot later rely on the security obtained, since constructive notice of such impropriety prevents its enforcement. In this situation, the bank should have been alerted of the possibility that Rizal was not acting on his own free will when Karim answered on behalf of him to the manager's question about why he was providing the guarantee. Consistent with the principles in Public Finance Berhad and DB Rubber Factory in 1994 and the English authorities of Barclays Bank and O'Brien and RBS and Ettridge, the bank is expected to warn the guarantor privately of the liability and risks, as well as advise them to obtain independent legal advice. XYZ Bank clearly failed to do so and is fixed with constructive notice. As a result of that, they cannot enforce the guarantee against Rizal. In conclusion, Rizal's consent to act as Karim's guarantor was procured through undue influence within the meaning of Section 16 of the Contracts Act 1950, as the transaction was clearly unconscionable. Similar to the English position, the bank's failure to ensure Rizal's independent consent means they cannot enforce the guarantee against him, as they had constructive notice of Karim's undue influence. As such, the transaction is therefore voidable at results option as stated in Section 20 of the Contract Act 1950.